Welcome back to It's Your Law. I'm George Curtis, and we have some guests to discuss wealth, preserving wealth, and what happens to our wealth when we pass on. Our second guest is Ben Brand. Ben, good to see you again.
Thanks for having me, George. Nice seeing you.
You're a graduate of what law school?
I graduated from the University of Wisconsin Law School this past December, and then was sworn into the bar in January of this year, and I've been working with Jack ever since.
Well, he's stern. He's a tough taskmaster. I personally wouldn't work for him. But
well, he definitely gets the job done. That's one way of looking at it.
Yes, he does. As a matter of fact, he sets a very high bar. I tell lots of people, if you want it done right, go see Jack Kelly. And this is one of the areas that your firm is very strong in.
Absolutely.
You have lots of clients who have something of value. Now, they don't have to be rich to have something of value. One person may feel that he has wealth worth arranging and planning because of lots of stocks or bonds or real estate. To another person, it might be a Civil War gun that his great-great-great-grandfather had, and it has value only to him and his family. But nevertheless, it's wealth and it's important, and your firm helps protect and preserve and plan wealth in all forms, doesn't it?
It does. And for instance, some people might have what we would consider a smaller estate and what the state of Wisconsin would consider a smaller estate. And that is someone with probate assets less than $50,000. And for people in that instance, they can still avoid, informal and formal probate procedures by executing what's called a transfer by affidavit. And that's something that's filed with the Wisconsin Department of Health and Family Services by the heirs of the decedent. So that's a post-death type of conveyance mechanism. And the heirs would file that affidavit showing, the death certificate of the decedent and establishing that they are indeed an heir. And then, for instance, if someone had a bank account worth $30,000, they then lay claim to that account and have it transferred to them that way.
Are there other things that don't have to go through probate? For example, life insurance. How does that work?
There are. Life insurance is inherently a non-probate asset, so that will automatically transfer to whoever the named beneficiary is on the policy upon the death of the policy holder. So that's another mechanism that you can use to avoid the probate system. However, it's a little important to make sure that you're always aware of your beneficiary designations and you update them as your life circumstances change. For instance, if you get a divorce, you might not want your ex-spouse getting the policy when all is said and done. Also, if your spouse predeceases you, you want to make sure that you're updating your beneficiary designation because if there are no beneficiaries in that instance, then it will go into the probate process and you're back to square one.
Well, many people have their major asset in some kind of a retirement fund through many years of work for a good company that matches or almost matches their contributions. Is that something you have to probate?
Again, those are another form of inherently non-probate assets. So 401ks, pension plans, Roth IRAs, any type of retirement account like that is also going to be payable on death to the named beneficiaries. So by having your beneficiary designations and designations that match the overall intent of your estate plan, that's another way where you can keep those assets out of the probate system and not bog them down, as Jack had referred to earlier.
I've often heard people say that a certain child has become the object of displeasure by the parent or somebody with money, and they're going to take his name off the account, or somebody else, they're going to put their name on the account. What is this business about bank accounts, and what difference does it make whose name is on it besides the person who contributed the money?
Well, bank accounts, if they're an individual account, those would be probate assets. You can avoid that by putting them into what is called payable on death status. And so you would basically change the account name to, the owner, payable on death to the owner's beneficiaries. And then at that point, at the time of your death, similarly, with the death certificate, you could have those accounts payable to the listed beneficiaries. And these can be updated, as life circumstances change again. So, if there's, a child who, you make the tough decision to disinherit, you can do that by changing the designation on your pay on death status.
Now, property that's owned jointly, that doesn't have to go through probate, does it?
It does not. Property that's owned jointly automatically becomes the property of the other joint title holder.
In my work, I keep bumping into people who are in love with cars. Car wrecks, old cars, rusty cars, and that sort of thing. What is the process when Joe dies and he owns a dozen cars out in his back field because he likes Edsels or for any other reason? What's the process?
Well, in the process of where you have a lot of cars or something like that, you generally would want to have some sort of plan in place with those. So, for instance, attached to a will, you could have a list of certain personal property which you would like to convey to others. Other times, too, you can just convey title by gifting it during your lifetime, and you can avoid those problematic areas during at the time of your death.
What would your recommendation be to people who really would like to know, do they need a will? Do they need a trust? Do they need a plan? How expensive is it to talk to somebody like you or John Kelly to find out what kind of problems they have and how many of them can be avoided?
Well, there's plenty of attorneys in the area with a lot of experience in these types of situations, and they deal with wills and trusts on a daily basis, and they're more than happy to talk to potential clients about these issues. And the initial conversation can be quite low in terms of cost, and I think it's definitely worthwhile if you have any assets whatsoever and you care how they're going to be distributed. To at least talk to a licensed professional.
Is it also important if you have had a divorce or some complexity in terms of a mixed family, in terms of children from more than one marriage, and avoiding future problems and disputes in those areas?
It is. It's very important in terms of divorce because obviously once a divorce happens, your plan for your estate is going to change drastically from what you had originally thought it was going to be. And that's why it's important, with things like life insurance policies and 401ks to update your beneficiary designations and to take those affirmative steps to make sure that, your overall estate plan is protected.
It's good to see you again in a professional setting. You're an honor to the profession. Welcome to the show, and working very, very hard for Mr. Jack Kelly.
Thank you very much, George.
Good luck in your career.
Thank you.
We'll be right back.